What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. We are in front of Judge Washington out of Michigan, and we have a pro se plaintiff who is suing a gas station for defamation. I believe specifically they accused him of stealing. The police were called, and he didn't steal anything. So now he's claiming that Speedway and the employees defamed him. It's an interesting case, but it's pro se, and yeah, he makes a lot of mistakes, but Judge Washington does help him out a little bit. You're about to see it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Call the case of, nope, I can't call that. That's her again. All right, the court will call the case of James Lafayette versus Dorothy Slagle and Speedway and 7-Eleven Corporate, case number 25C 2099.
One. Good
Good
afternoon.
afternoon, Your Honor.
Good afternoon.
Please state your name.
James here.
Thank you.
This is Sarah Reasoner, P number 85573, appearing on behalf of the defendants.
Thank you. This is your motion today, Ms. Reasoner, for summary disposition. It's a C8 motion, is my understanding.
Yes, Your Honor. I believe the motion's straightforward. Mr. James filed a complaint alleging that the defendant, Speedway, and its employee defamed him. That complaint doesn't contain any details about the case or any facts that satisfy any of the elements of defamation. So we've moved to have the complaint dismissed.
Mhm. And you saw his response to that in he called it a rebuttal, but you did see that, correct?
Yes, Your Honor. I understand that Mr. James included detail in his rebuttal. We would stand by our motion that, you know, we've discussed this with him in the past and told him and asked him if he could amend his complaint to include details in the complaint. He didn't do so. So we ask that it be dismissed because it doesn't contain any allegations that explain the basis for the defamation claim here.
Okay. All right, Mr. James, I did see your rebuttal, obviously, and I saw that you did put details and the rationale and what was said that leads you to believe that you were slandered in that particular response. The thing I'm concerned about right now is Ms. Reasoner is indicating to this court that they've talked to you already about amending your complaint to comply with the rules of the court, and you have failed to do so. So why haven't you amended your complaint if you've been warned already that it does not meet the standards to be able to proceed?
Your Honor, I understand that somewhat. I misunderstood defense attorney, I believe the name is Stager. And while we were in conference, I added all the necessary elements to the complaint. I
don't have an amended complaint, sir.
Okay, and I understand that, Your Honor. I had been sick and under doctor provision. I barely got an opportunity to file something yesterday, but I just was sick and under my doctor's care. But what I was saying, though, Your Honor, is that I was under the assumption that the defense counsel had the police report and the response to my complaint from the defendant, Dorothy Slagle. And in her response, she brought up the element of theft. And in the police narrative, he brought up the element a theft in the report, police report. And so I was,
Mr. James, I fully understand what you're saying that they said was wrong about you. That's not the issue. The
Okay.
issue is that a complaint has to comply with the rules of the court, which have to have all that information in there. So you can tell me what happened over and over again, but your complaint is not sufficient. This is a C8 motion. So a part of the problem with people trying to represent themselves is that they don't understand the way the law works. And the way it works is that if your complaint doesn't satisfy some basic requirements, whether there's a police report attached or not, your case gets dismissed. So they're moving today to dismiss this case because your complaint does not comply with the requirements. You filing a rebuttal to their motion doesn't fix your complaint. You have to fix your complaint, and I can't give you legal advice, sir.
right, and that's why I came to this second conference, because I was under the impression that I still had time to submit that evidence.
It's not the evidence. It's the
I mean, not the evidence. I understand what you mean. That was misspoke. I was planning on getting an attorney, but I wasn't able to at the time. So I tried to bring the case forward. The first conference. Pardon me?
I'm aware of that.
Yes, and I was under the impression that I could bring forth. I wanted to add an extension to it because I needed the time to file the response to their motion. I wanted to see whether or not I could extend that time so I can obtain counsel, and also I needed an extension, but I had some medical problems going on, and I was under medication, strong medication, so I wasn't able to respond like I wanted to respond to the Michigan Court Rule 2.116. I think it was. I understood what it was saying, but I needed more time, and I was they called me last night. Counsel called me last night and offered me a settlement amount, and so I was still under the impression by them offering me an amount. They accepted the fact that the element of stealing was some omission. I felt it was some omission. So I was coming to this conference. I didn't call them back. They called me last night and this morning, and I rejected the settlement amount. I was under the impression that I could have time.
All right. That's not me breaking up. That's this guy, and I think he's in the courthouse. It looks like the lobby of the courthouse. They have an iPad set up so you can zoom in because they don't let anyone in right now because it's under construction. But yeah, they offered him a settlement for a defamation lawsuit. I don't know. I would accept that. Defamation lawsuits are really hard to win, especially if you're pro se, and they offered him a settlement, and he said no. He must really yeah, I don't know. They accuse him of stealing. I don't know. It's kind of weird. I mean, I understand his ego's hurt, and yeah, that looks bad. But take the settlement. You'll win.
Time enough to respond to the make it simplified to respond to their motion.
Ms. Reasoner and Mr. James, do the two of you want to talk to see if you can come to some resolution today? Since he's saying, is it true that someone called for a settlement offer?
Your Honor, yeah, my client's always willing to settle these cases. I guess it's up to Mr. James if he wants to talk, because I think the ball is in his court to respond. I mean, I think the issue on our end is I don't know that there's any that any damages, if he even got any, would be nominal at best. So I don't, if we're happy to continue talking about settlement, but
Well, it doesn't sound like a settlement negotiation is going to be fruitful today based on the fact that you're talking nominal damages. I don't know what that number means, and I don't want to know because I can't know under the law, because I don't see that there's a jury demand in this. So I'm not trying to talk to you guys about what numbers you're passing back and forth. I was trying to find out whether it might be fruitful, but it does not sound like it's going to be. The reality is what I have before me is a C8 motion today, which is a motion to dismiss the claim based on the fact that the complaint does not meet the standards for the court rule to make out a claim. He has failed to indicate in there any details of the slander. He did in his response indicate that what the details are, and there clearly aren't details, and he's going to pay, from what I hear, for an extension to give him a chance to amend its complaint. And Ms. Reasoner, I don't see any reason why I shouldn't do that. The law says that the filing of complaints and the response to amend are liberal. Why wouldn't I give him that opportunity? I'd give an attorney the opportunity to amend.
Sure.
Yes. Excuse me. No, Honor, can I speak?
No, I'm talking to her.
I'm sorry.
Sure, Your Honor. I guess the only thing I would say to that is I would point out that, this case has been pending for several months. My understanding is that at the last conference, there was a discovery schedule set. My understanding is my colleague talked to Mr. James about the issues with his complaint around the time of that conference. And so, these issues have been out there for a while. But I understand, Your Honor, that the rules for amending the complaint are liberal. Our position on that would be that, this is set for a pretrial conference discovery. The discovery period had closed. And, we raised this issue several months ago. So, Mr. James had several months to amend the complaint. Or let us know about his health issues and ask for us to agree to extend the timeline of the case so that he had time to take care of that and then get an amended complaint on file.
Thank you. Anything else you want to say before I make my ruling, Mr. James?
Yes, I would ask the court if they would allow me to amend my complaint at this junction and take into account of exigent circumstances.
Thank you, sir.
And that's about all I can say. I also would like to note that, the only reason why we didn't settle this morning on that was because of a letter. I only requested counsel to ask the defendant that slandered me in my capacity as because I was doing business there too. I just asked for an apology, a letter from her for apology. It wasn't the monetary amount that they offered me. It was what I was focused on was the apology. That was plain and simple. That's where the disagreement lied this morning and last night. I have trouble. They called me today and said that we'll give you the money, but we can't get her to write a letter of apology. The money was frivolous. It was the fact that she denigrated me in public by accusing me of stealing and actually profiled me as a dope fiend going in there to use the bathroom. And I resent that. I asked the court also to if the ruling is adverse to me, to accept the motion for appealing the case. I guess you would give me that paperwork anyway. If the ruling is adverse and I don't get the opportunity to address the issue of what happened insofar as being slandered and called as a theft, a stealer in front of customers and in front of people that I was talking to do their taxes. I think fundamentally speaking, and in the eyes of justice, if the case is being dismissed on the grounds of timeliness, I think that the fundamental aspect of it and the discretion of the court can have some bearing on this to bring it about a reasonable solution. In the alternative, I came here since they gave me an offer, I came here to modify that offer at this forum so that it'll be part of the record. Since she said,
All right. So that explains a little bit more what's going on. So he was at a speedway trying to get business to do people's taxes. I mean, maybe they're friends. I don't know. Sounds like soliciting to me. Doesn't matter. But yeah, his ego was hurt. Was called a thief. Apparently didn't steal anything. He wants an apology. They're not giving him an apology. Well, it looks like he's going to get time to amend his complaint, which sounds like it's just going to be dismissed anyways. Again, defamation is hard to prove, especially if you're pro se. Just saying. All right, let's finish this one up.
Said that a letter would be forthcoming. So that's all I have to say on it.
Right, thank you. All right, as I said earlier, the right to amend a complaint is considered and supposed to be liberally construed, or in a defense for that matter as well, but it's for a complaint. In this particular case, the court is going to grant Mr. James an opportunity to amend his complaint, and I'm going to give him a time frame to do that. Sir, you need to file your amended complaint within 21 days. You got 21 days to amend your complaint. If the complaint is not amended at that time, then the court will.
Thank you, Your Honor. Could I also say,
You're not talking over me, please.
I'm sorry.
If the complaint is not amended by that time, then the court would consider at that time the motion to dismiss of the C8 is without prejudice, meaning that if it's not amended timely, then you can bring your motion again, Ms. Reesner, and I would consider it at that point. But I'm giving you 21 days to file your amended complaint.
Thank you, Your Honor.
Thank you, Your Honor.
And what I'm going to do is give you all another court date. I'm going to schedule it for October 9th at 2:00 p.m. And sir, just so the record is clear, it's 21 days from today's date, okay?
Okay, I had an appointment on the date, Your Honor, but I'll cancel it and reschedule.
Sir, whatever date you may have an appointment on doesn't affect you filing a document. You need to amend your complaint
I see what
by
you're
that date.
No, I was thinking that you were saying that the 8th was at 2:00.
The October 9th?
Oh, it's 9th. Okay, thank you, Your Honor. I have really wrote it down wrong. Sorry.
Okay. And then Ms. Reasoner, this is your motion, so can you prepare an order to that effect and submit it to the court?
Yes, Your Honor, will do.
Thank you.
Thank you.
All right, that's it. I think this hearing is going to be interesting. Hopefully, we'll get to see the rest of this play out. I kind of hope Mr. James gets gets whatever he's asking for. Probably not going to happen though. Not a case that you want to go pro se on. It really isn't. All right, that's all I got. If you liked the video, please hit the thumbs up. I would appreciate it. That's it. That's all I got. Till next time. Bye.